Hey guys, this is John Watts. This is part 2 of our series on answering discovery in a debt collection lawsuit. Now, if you have a lawyer, obviously your lawyer will take care of this for you, work with you on it. If you're doing this on your own, then hopefully this will be of some help to you. Obviously, I'm not giving you legal advice. I don't know who you are or what your specific circumstance is, and you've got to know your own rules. It may be different, the rules where I practice versus where you've been sued. So again, if you represent yourself, you really have to have knowledge of an attorney. And so you've got to study your own rules. And I'm going to answer these kind of like if they were directed towards me. Okay, these are real questions and very similar to discovery requests that we get. And most of the firms that practice in Alabama that are debt collection firms are more of national firms. So it's not necessarily somebody in Birmingham, although we certainly have that. But this is pretty typical. You'll see there's 3 types of request or discovery items. Number 1 are interrogatories. And if I've done it correctly, all those will be in yellow. Request for admission, that is a fact that you say yes or no to. Those are in light blue. And somewhere down here, green. Request for production, that's saying, hey, give me documents. And this is typically how the collection lawyers do this, where they're all just sort of jumbled up. Now, in every other kind of litigation, we tend to have them very separated. So here are my 17 interrogatories, here are my 10 requests for production, and my 29 requests for admission. That's not how the collection lawyers do it. I'm going to maybe hallucinate that this is to be a little confusing. If you are not a lawyer, you're doing this yourself, trying to understand, like, well, wait a minute, why does it go from, number 1, 1, 2, 3, 2, 4, 5, 6, 7, 3, 1, 2, and there are different rules. And we talked about these a little bit in the last video, as I recall, so I'm not going to go over exactly what these are, but let me just kind of walk you through the process of how I would answer these questions if these were directed towards me. So interrogatory number 1, identify all persons who participate in the preparation of the answer. That's just who helped me to answer these questions. It may just be me, it may be a spouse, it may be a child, a parent, whoever it might be, and you just list those people. Now, I cut out the part, there's a whole long list of definitions. They'll say, well, here's what we mean by identifier, here's what we mean by the account. And you do have to look at that. Sometimes they get a little carried away in that. Okay, so, at least what I would do is I would be reasonable in my response. Doesn't mean I'm going to necessarily give them, fingerprints and blood samples and, social security cards for everybody involved. Okay, so request for admission number 1, you're a resident of the county in which the suit was filed. Pretty simple. If you're sued in Jefferson County, are you a resident of Jefferson County? It's either yes or no. And the more common way of doing it is you say admitted or denied. Now they're doing this because under the FDCPA, Fair Debt Collection Practices Act, they can sue you in the county that you're a resident of. And number 2, request for admission gives us the second part. You sign the original application for the card or whatever the loan is in the county in which suit was filed. So 2 places they can sue you under the FDCPA: where you live or where you sign the contract. Now, that can be different than what are called your venue laws, which is your state law for where can you be sued. But they're just asking here for basically to find out, hey, are you claiming we violated the FDCPA, which they do from time to time. All right, request for admission number 3, use the card to make purchases or obtain extensions of credit in the county in which the suit was filed. Again, that's going towards, they want to argue, Judge, this is the right place where we sued you. Now, let's go back to interrogatories. Number 2, if you contend or believe the venue of this action, in other words, where we brought the suit, is not proper in the county in which the suit was filed, state the factual basis. So in other words, if, and I'm using Alabama counties, but of course a lot of these overlap, I was sued in Jefferson County, but really I live in Shelby County, and I signed the application for the card in Montgomery County at a department store or bank or wherever, then I would say, I don't live in Jefferson County. I live in Shelby County, and I did not sign this in Jefferson County. I signed it in Shelby County. Okay, and then you also can address where you use the card. All right, number 4, request for admission. Pretty simple. You applied to the issuer, so that would be Bank of America or Chase or whoever, for issuance of the card. I mean, either you did or you didn't. And you got to be truthful when you do this. At least that's the approach I take. So if it's true, I put admitted. If it's not true, I put denied. Now, if it's something I don't know, then I would explain why I can't say yes or no to it. Okay. The card was issued to the defendant. Again, I mean, it's either you got the card or you didn't, and it came from, let's just call it Capital One. It came from Capital One or it did not come from Capital One. So again, nothing really tricky about it. You just answer it. You received the card. So you sort of see the progression here. You applied for the card, they issue the card, you received the card. We'll look here at the next one, admission number 7. You accepted the card. In other words, you didn't turn it back in, send it back, say, I reject this contract. No, you accepted the card. All right, interrogatory number 3. If you deny receiving the card, then who do you think received it? Now, if you don't know, and let's imagine you go, I never got the card. I have no idea what you guys are talking about. Well, and I have no idea who would have received it. You just say, I did not get the card, and I have no idea who did get the card, if there was one issue. All right, now they're talking about production of documents. So if you deny receiving the card, please produce all correspondence between the issuer, Capital One, for example, and the defendant. Well, again, it's pretty simple. Like all the correspondence, it could be emails, it could be letters you sent, letters you received, monthly statements, whatever the communication is, they're entitled to get that unless you have a good reason to object. Request for production number 2. If you denied having received the card, please produce your checking account records for the period of, and then they would put that in there. Now, I'm not going through these and saying, well, let me explain to you every possible objection you can do. I'll just tell you, my personal view is I very rarely object. And that's because discovery is supposed to be wide open. They have very free reign to get this. And when I sue these guys, then that's the position I take. And so I don't want to say, well, when you sue me, it's really, really narrow. But when I sue you, it's very broad. They do the opposite. And I think they look like hypocrites. So that's just my view on it. So here's another request for admission. You signed the back of the card. Well, either you did or you did not. So you put admitted or denied. Request for admission number 9. You use the card to make purchases. Now, this is saying you, okay, or in my example, me. Like, did I use the card to make purchases? Not saying did somebody else use the card, but did I use the card? Okay. So I say either yes or no. And then how about request for admission number 10? Use the card to obtain extensions of credit. And that's just sort of a fancy term of saying I went down, I bought something, and I paid for it with my credit card. It's really the same thing as using the card. There's a slight technical difference, but it's very, very technical here. Okay. Interrogatory number 4. If you denied having used a card, then basically tell us who you think used it and did you authorize them to use it. So if you say, nope, I never used the card, I always got my father or my son or my wife or my best friend to use the card and I authorize them. See, that's what they're trying to capture here in this interrogatory number 4. So again, you answer it honestly. Now we've got 3 admissions here. The issuer, so we'll just call that Capital One, made cash advances to me, the defendant, either as actual cash or in payment for purchases. Well, first of all, cash advance is where you get cash. So, they're sort of redefining words here. So I would just say, that's different than paying for purchases. That's not a cash advance, okay? They're wrong on that. So I would just say, the question is, did I get cash advances? Either yes, no, or I don't remember. And then I would go ahead and answer it for purchases. Either yes, no, or I don't remember. Did you accept those advances? In other words, if you did a cash advance to get $500, did you accept the money? By accepting each such advance, You became bound to pay the amounts of such advances plus any additional charges provided for in such agreement. Well, now this time about the terms and conditions of the credit card. And now some people might object to this, say, well, I think that's kind of legal, but I mean, honestly, for me, it's pretty simple. I mean, there's a contract, those terms and conditions that tell us when you have to pay, how much you have to pay, what the interest rate is, the late fees, all that stuff. If I'm using the card, obviously I'm bound by those terms and conditions. So, I would admit this unless I thought there was something wrong with the question. Just looking at it quickly, I don't see anything that would be wrong with it. Interrogatory number 5, if you denied having accepted each advance, then identify those advances or charges that you dispute. Now, remember this, you have an obligation to do some investigation. You do not have an obligation to have a perfect memory. If you say, I did 100 charges a month for 10 years and they're asking me, well, identify which one. I don't have my statements. Well, the answer is probably, I don't remember. Okay? So again, you just have to be truthful. Going back to admissions now, until at least the charge-off date, you received on a monthly basis, a statement of charges. That's just your monthly statement you get, whether it's electronic or in the mail. So you just admit or deny that. Now, here's one thing to think about. Let's say that there are 3 years at issue, 36 months, and you receive 30 monthly statements, but 6 you did not get during that time period. I'm talking about, from when it started until this was charged off. Well, if you didn't get all those, then you could say either denied because you didn't get those every month, or you could explain it, denied, I did not receive one every month. So I don't think they were sent on a monthly basis. If they were sent on a monthly basis, it would have been 36 times in a row. All right, so now requests for production. You'll see how these are related. There's a logical theme to it. They're saying, okay, produce all those billing statements that you got from Capital One or Synchrony Bank or whoever. Now, interrogatory number 6, if you've refused to admit request for admission number 14, tell us the factual basis. So let's see, what was 14? Oh, that you got the monthly statement. So, and this is pretty common. If you deny an admission, they'll probably come back and say, we'll explain it. Okay, so some people would just deny the admission, then explain it in the interrogatory, or kind of do it both places. It doesn't really matter to me. All right, request for admission number 15. You did not, within 60 days of any billing statement, send the issuer a written dispute. So that's under what's called the Fair Credit Billing Act. And if you dispute within a certain time period, typically 60 days, then until an investigation is done, I really can't charge you interest on those amounts or report you as late, things of that nature. Now, if you don't, that doesn't mean that you're stuck with it. The collection lawyers will tell you that's what it means, but that's not how I read the law. Okay, but that's what this is kind of getting at here. All right, request for production number 4. Give us all the correspondence from you to the issuer disputing any billing statement, proof of sending, receipt of such correspondence. So in other words, if you have a letter and you've got a green card that came back, you sent certified mail, FedEx, whatever, they're just saying, we want to see anything where you disputed anything on the monthly statement. Now, number 16, you failed to repay all of the advances made by issuer on the account. We'd have to know exactly what they mean by advances here, okay? And you would also have to know whether or not you agree that you did refuse to pay all those or failed to pay all of them. And also that they are accurate. I mean, there may be advances, whatever that means, charges, cash advances, that they say the issuer gave to you, but you say, hey, I never received those. So you might have a basis to deny. Request for production number 5, if you refuse to admit admission number 16, produce true copies of all payments made on the account. So we back up, they're saying, admit that you failed to repay all the advances. If you say, nope, I don't agree with that, they say, all right, we want to see all payments made on the account. Could be bank statements, could be canceled checks, could be monthly statements that show the payment, whatever it is, they're asking you for this. Now, request for admission number 17, the balance due, owing, and unpaid after allowing all just and lawful payments, credits, offsets was blank dollars as of a certain date. Now, understand what they're doing and make sure you're truthful in your response, but appreciate the seriousness of this so that you can really, really study it. If you say admit, then you are agreeing that you owe the debt at least as of whatever that date is. Now, you're not agreeing you owe it to the debt buyer who's suing you, but you're agreeing that you owe the debt. So you've got to say, okay, is it the right amount? Have they only done proper charges? Have they only put proper cash advances, purchases I've made? Have they given me credit for every payment, every offset, everything? Are they doing the interest rate right? Are they doing the late fees right, the over the limit fees right? And if you believe that they are, then you would consider saying admit it. Now, if you don't, you'd say deny. Now, notice this. If you refuse to admit number 17, that's the one right here, state the balance that you believe has been due on the account as of the date and how you calculate that. So they're kind of putting it back on you, saying, well, if you don't agree that we have the right amount, tell us what the right amount is. Now, if you know it, you can tell them and explain it. Now, if you don't know it, because again, this could be, charges from 4 or 5 years ago, and it's changed hands multiple times, and now this debt buyer is suing you and saying, well, how much was it? You're like, I don't remember. That may be your answer. All right, number 18, you made this request for admission, you made no payment on the account since whatever date. Usually this is the charge-off date, okay? Again, it's either true or it's false, and you would know that. Interrogatory number 8, if you refuse to admit request for admission number 18, state the date and amount of each payment that you made on the account since, again, likely that charge-off date. So if I say denied to number 18, that means I have made payments on the account since, we'll just make up a date, February 1st, 2018. So they say, okay, well, John, since you refuse to admit this one, explain to us every payment you made since February 2018. Now we go back to request for admission number 6. If you refuse to admit, request for production. If you refuse to admit request for admission number 18, remember that is you haven't made any payments. Produce true copies of all documents on which you base your refusal to admit. In other words, that would be your bank statements or your canceled checks or whatever it is that would show that you did make payments after, in my example, February 2018. Now, we have a whole series here of admissions. At least 45 days prior to the date on which you were served, you received a letter from the plaintiff's attorneys requesting payment of the account. This is going to be typically called a demand letter by the collection attorney saying, hey, we now represent, Midland Funding, and we're demanding that you pay this money. There are certain places where they do have to give you notice before they sue, and so that's what they're trying to do here, is show that they did that. This is a critical one. Remember, I've harped for years in videos. I wrote a blog post back in like 2007 on this. There's a difference between you owing a debt and the debt buyer owning the debt. And if you admit they own the debt, well, then they're the same as the original creditor. So the account was sold to plaintiff. I'll just tell you this. I have never admitted that in any of these cases because I have not seen them produce the purchase agreement and all the information required to show me that they have purchased the account. So what we do is say deny. Now, they're trying to do kind of some synonyms here. Well, it was assigned to plaintiff. I don't have any proof of that. You sued me, Midland, Portfolio, whoever. So what? There are all sorts of terrible lawsuits out there that have no basis. That doesn't prove anything. You know what suing me proves? It proves you sued me. That's all it does. So the account was assigned to plaintiff. For me, that would be a denial unless they showed me proof. Plaintiff is presently the owner of the account. Same thing. I don't have any proof of that, so I'm going to deny it. Obviously, you do what you feel is best. Interrogatory number 9. If you refuse to admit requests for admission number 22, state the facts on which. So let's go back to 22. Plaintiff is presently the owner of the account. So what would we write here? Well, I'd probably say, I've never done business with you, portfolio recovery. I have no idea if you purchased this account. I haven't seen any proof of that. I never had a credit card with you. I never borrowed money from you. You never fixed my air conditioner. You never fixed my car. You never, did anything for me. Okay, you're a stranger. And I have no reason to believe that you own this debt. Okay. Now again, I'm just telling you kind of what I would say. You use your own judgment on it. Number 23, admission. Defendant, that would be me as the defendant, is indebted to the plaintiff, let's call it LVNV funding, for the amounts asserted in the original complaint. This is sort of the killer, right? I mean, if you say admitted to this, the case is over, okay? At least as a practical matter. Now, if you don't respond to a request for admission within 30 days, typically it's automatically admitted. So guess what? You just lost your case. Okay. So that's why these are, and look, we're on down here, page 6 of 10. We're at the 23rd admission. We've had 9 interrogatories. How many? 6 requests for production. And they give you this one that if you miss this, basically your whole case is over. Interrogatory number 10. If you refuse to admit request for admission 23, state the facts on which you base your refusal. Well, for me, I'd say, because you don't own the debt. So I don't owe you. And I disagree with the amount. I don't agree that I owe $5,413.27. So, pretty easy. Request for production number 7. If you refuse to admit request for admission 23, produce true copies of all documents on which you base your refusal. Well, so let's go back up. Make sure we know what we're talking about. You're indebted for the amounts asserted. Well, I don't have any documents that say LVNV did not purchase the debt. Okay? I mean, it's like somebody saying, show me the documents that prove that, you did not think about something 5 years ago. Well, how would I have those documents? Okay. So it's just kind of silly. But again, this is designed to intimidate you so that you're like, oh my goodness, I'm like, I must have to have some documents to prove it. No, they have to prove, in my view, they have to prove that this debt buyer owns the debt. I'm not going to have those documents. They will have the documents if they exist. The funny thing is they won't give them to me. Kind of weird, huh? All right, interrogatory number 11. If you contend or believe the debt that's subject to the suit is the obligation of anybody else, then identify them. So, in other words, if you say, well, I was really just an authorized user, or, somebody stole my card and they're really responsible, they're just saying, hey, tell us who that would be. It's a pretty reasonable request. All right, request for production number 8. If you think this is an obligation of anybody else, produce those documents. So again, pretty reasonable. You may not have anything like that, but if you do, they're asking for it. Request for admission number 24. You're not entitled to any set-off for sums unconnected with payments that have been made by or on behalf of defendant. It's kind of a oddly worded question. So let's look at this. So I'm going to do it as you. So you're the one being sued. You are not entitled to any set-off, which would be so kind of a reduction of what you owe for sums unconnected with payments that have been made on your behalf. So what they're saying, let's say you owe $5,000. You say, well, I made $1,000 of payments, so I owe $4,000. But then you say, but you know what? You guys sued me in the wrong county. I have a counterclaim I can file against you, and you violated this law and that law. Well, those might be considered set-offs that would reduce the amount that's owed. And they're saying, admit that you have none of those. Well, you got to be really careful before you admit that, because if you admit that, again, the most common thing is you just don't respond to these. And then they're, boom, automatically admitted. Most places you can try to get the judge to unadmit them, okay, and give you a chance to answer. But that is an uphill battle, okay? So try to avoid that. All right, interrogatory number 12. If you refuse to admit request for admission number 24, state the facts. So again, you see the pattern here. We have an admission, and then tell me the facts, and then give me the documents. You see the pattern? So I want you to admit a just terribly damaging fact. If you don't, you have to explain why not, and then you have to give me the documents that prove it. Okay. Now again, if there are no documents, there are no documents. I mean, like imagine this. You say, they go, admit that you applied for the account. You go, denied. They go, well, explain it. I never applied for it. Give us the documents. Well, there is no document. There's no document that says I haven't applied. There would be a document if I did apply, but if I did not apply, obviously there's no document. So just understand if you don't have the documents, you say, defendant does not have the documents. At least that's what I would say. All right, so interrogatory number 13, who do you intend to call as a witness? And they're just wanting to figure out, if we go to trial, who's going to be there. Interrogatory number 14, do you have an expert witness? Request for protection number 10 is going to be related to your expert witness here. Now, if you notice this, interrogatory number 13 is actually a witness. 14 is the expert. That's just a typo there. They mean number 14 because they're talking about experts. Okay. Now, I'll just say the way I do it. When I realize they've made a typo, I don't get cued on that. I just would say, in responding to request for production number 10, I would say, it says interrogatory number 13, but I believe you mean number 14, and that's what I'm answering. Okay. Interrogatory number 15, all persons whose mental impressions or opinions have been reviewed by any person who you may call as an expert witness. Again, very rare that you would have an expert witness in this type of thing, but this is pretty standard language in just normal litigation. So if you identify any of those people, that's actually, now that I look at it, they're really just, they've kind of duplicated this request for production number 10 and 11. So see, 10 has to do with 13, which is not expert witnesses. Interrogatory number 14 is expert witness, and that's what they're doing here. Okay. So, and I take that back. I mean, they have some slightly different language here, but anyway, it's very unlikely you have an expert. Request for production number 12, correspondence between the plaintiff, that's the debt buyer suing you, and you, or the lawyers, okay? Number 13, correspondence between the issuer, that'd be like Capital One, and you. Number 14, all statements of the plaintiff. Again, that's the one that sued you or its attorney. So maybe they've told you something over the phone. Maybe they sent you a letter, whatever it is. So a lot of this you'll see, it's kind of like this one request over here, this one request. There's overlap. And so if you've already produced it, you could say produced in response to, I don't know, number 7, or you just put produced. Okay. Number 15, produce all witness statements. Now, typically we can object to this, what's called work product and attorney-client, mental impression. There are all sorts of stuff. Depends exactly how your state words it. But it's the idea that if I go out and do this work and gather up these witnesses, I don't necessarily have to share that with them. I have to tell them about the witnesses, but I don't have to necessarily give them everything if they can go get their own statement. So that's getting kind of deep into the weeds. So you just have to figure that out in your state. All right, interrogatory number 16, if you're disputing only a portion of the account, identify which ones are disputed and which are not, and explain why. All right, here's another admission. Each of the charges comprising the account, was reasonable. Under a lot of theories, they have to prove that what was that the charges were reasonable for those to be then binding on you. Okay, and again, I'm not going to go into the details of exactly all the theories here of how the collection lawyer has to prove their case, but I would just take it literally. I mean, each of the charges comprising the account was reasonable. If you agree, you say admit. If you disagree, you say deny. If you refuse to admit, then explain this and give copies. Now, on which you base any assertion of a set-off. That's not really Again, it's a little sloppy here. That would really go to a different request for admission, but you know, this is reasonable and this is talking about a set off. So I would just try to answer it as fairly as you can. And that's actually the end. Now, again, you have to look at your state. In my state, interrogatories have to be notarized. Requests for production responses do not. Requests for admissions do not. If we're going to object, we need to object within the time period. Now, if you get an extension, you just want to make it clear that that's your extension to respond to the discovery, which can include objecting. If you just say answer, then it's a little bit of an argument. Did you waive your right to object and that type of thing? So hope that this was helpful to you. Let me know what questions you have, that not specifically in your case, but just that I can answer in another video, and I'll be happy to do that. Okay, guys, have a good one. Bye-bye.